I'm Jen Shaw. We spend our days helping employers sort through messy workplace situations, often in real time and often with a lot on the line. On this podcast, we'll walk through those issues, what's coming up, what actually matters, where employers get into trouble, and what to do next. No theory, just practical guidance you can use. Hello, everyone. Welcome to the podcast. Before we get started, I want to give you a quick reminder about an upcoming program Joe and I are doing on June 2nd called Getting Investigations Right, a California Employer's Playbook. It's a complimentary webinar focused on one of the hardest things employers and HR professionals do, conducting workplace investigations that are practical, defensible, and designed to hold up under scrutiny. We'll cover everything from intake and planning to witness interviews, credibility assessments, documentation, and common mistakes that create risk. There will also be live Q&A. Today's topic on the podcast actually overlaps quite a bit because investigating third-party harassment claims presents some unique challenges. We hope you'll join us on June 2nd. Registration is at employerslawyer.com/investigations. So let's get going here with Joe Beachboard. Hi, Joe. How are you today?
I'm doing well. How are you, Jen?
I'm good. I'm very happy to be here. I cannot believe summer is coming in Sacramento. I hope things are nice in your neck of the woods down in Southern California, but I can feel it starting to get hot here. So I'm not looking forward to the summer. Okay, so Joe, we're going to be talking today about when the harasser is not an employee. And we're going to provide some investigation strategies for employers. Okay, and all of you, just to set the stage here a little bit, remember that when we're talking about third-party harassment claims, we're talking about conduct that is perpetrated by a third party, like a customer or a vendor or a contractor, a resident, a patient, a client, a parent, if you're at a school, for example. And the idea here is that as an employer, you have to protect your employees from all of these folks, not just from other employees who you are paying, right? Also from anyone they come into contact with as part of their jobs. So what's interesting is when you're investigating conduct that allegedly was perpetrated by another employee, you have a little more control. You have the ability to do a little bit more when you're doing the investigations. When you're dealing with a third party, somebody who you are not employing, things can become a little bit more challenging. So what I want you to first think about is something that Joe and I hear a lot, which is, look, if a third party engages in this conduct, that is just not our problem, right? It is not our employee. It is not our problem. And that's something that I actually want to start with you about, Joe, because we have both seen, we've talked about this, we've both seen in our, several decades of practice that these third-party harassment claims tend to be underestimated, right? Employers really sometimes don't appreciate the potential liability that can be associated with these claims. Why is that? Where does this come from, this sort of lack of understanding that these claims can be just as expensive, for example, as any other claims?
Well, Jen, I think there's several reasons for that. I think some of it you've identified there. There's a fundamental lack of understanding as to what the obligation is of an employer in these situations. I think some of it can be just about lack of time, right? I mean, HR professionals are so busy, and it's like, I've got enough issues trying to manage my own employees. I can't worry about these independent contractors or vendors or customers or whatever the case may be. I just don't have the time for that. And so sometimes it's lack of time, sometimes it's lack of concern, and sometimes it maybe is too much concern because we're focused on the business relationship and we say, oh, well, we don't want to step into that because that might affect one of our client relationships, or that might affect our revenues, or that might affect whether or not we get that big contract that's coming up. So I don't want to get in the middle of that, especially if I'm in HR. So I think those are some of the reasons Very different, but I think those are some of the key reasons why we see people not focus appropriately on third party misbehavior.
Well, I think you're so right about that, Joe, because when I talk to HR folks, and I know you have a similar experience, there's always a little bit of tension with the business people, right? Because the HR folks are saying, look, we've got to hire this way. We've got to do write ups this way. This is how you have to administer a leave of absence, for example. And a lot of times I think the business folks are like, no, I don't want to follow that process. I don't want to do that. And I understand why, particularly in California, but not just only in California. I think we get a bad rap sometimes that we have the most protective laws and the most burdensome regulations for employers. But the truth is, there are a lot of places around the globe where you really have to follow some pretty strict requirements when it comes to everything you're doing in terms of running a business with your employees, right? How you hire, how you fire, how you drug test, all of those things can come up. So when you get the business involved and you're telling the business, hey, we've got a concern about Jen, she's one of our, most important clients, or she generates the most revenue for us, but we still have an issue. The business people are going to be like, yeah, whatever, like figure it out, but we need the revenue, right? This is an important relationship that we have. And in many ways, I think that makes it more difficult than employees, because the business people are thinking of the employees as important resources, of course, and important, assets of the organization, but they can't quantify it the way they can quantify the loss of revenue from an important client, for example, right?
Totally agree. It's a difficult problem for HR, right? You want to educate the business as to what the risks are, but you don't want to be perceived as an impediment.
That's right. And I think a lot of times as employment lawyers, we're perceived as the impediment, right? We're perceived as just tell me that I can do what I want to do, right? Well, if you're calling me to get legal advice, I'm going to tell you what the risks are. I'm not going to judge you. Whatever route you go is fine. I mean, that doesn't matter to me. But I got to do my job to educate you. Otherwise, what are you paying me for, right? I haven't told you the best practices. I haven't told you where the risky steps might be. So I think in many ways, HR folks and employment lawyers are kind of in the same boat, right? We're often delivering a message that people don't want to hear.
True, but HR is in the business, right? And so they're in the business. We're outside of the business. And I think that makes it a little easier for us to say, well, I don't care what you do. My job is to just
Absolutely.
tell you what the risks are. The HR person, that's not quite as easy.
No, and I think it's really tough. I have a lot of empathy for these HR folks. I was at a conference last week where we were talking about how to build a positive culture. And the HR folks were saying, we have all these great ideas, but we got to sell them to leadership. We got to sell them to management, right? That's tough because they want to implement them, but they can't do it without having people on board. Let me ask you this, Joe. Does California law require anything different when it comes to dealing with these third-party situations as opposed to internal situations that may involve other employees?
Well, Jen, you mentioned it that California can be a difficult place to run a business, and both you and I have run businesses in this state, so we certainly understand that. But I'm happy to say this is one area in which California is pretty consistent with most of the country. Now, there has been some recent attention to a case that went up to the U.S. Supreme Court, or at least they asked the U.S. Supreme Court to hear the case. This was a case from what we call the Sixth Circuit Court of Appeals. And the Sixth Circuit Court of Appeals had reached a conclusion inconsistent with the holdings of many other courts, specifically as to when can an employer be responsible for the inappropriate behavior of a third party. Most of the country, including California, have held that it is what we refer to as a negligent standard, right? Did the company know or should have known and failed to take appropriate remedial action? But the Sixth Circuit said, oh no, that's too easy of a burden for employees to meet. We need a higher burden for employers. And so employers can only be held responsible if they intended the harm or were willfully negligent with respect to whether or not the harm could occur. So the plaintiffs in that case, the employee, appealed that to the U.S. Supreme Court and asked them to resolve this dispute and decide what the right standard is. The Supreme Court declined to hear the case, but the rest of the country, including California, other than Michigan, Ohio, and Tennessee, which are the states that are within the Sixth Circuit, the rest of the country uses the negligence standard. So for once, Jen, our standard, our burden as employers is similar to that for every other employer in the country. The only bad side is the damages risks are so much larger here.
We do have greater damages, right? I mean, not only do we not have a damages cap like they do under federal law, for example, but we have juries and judges and mediators and arbitrators that are very willing to go into the big numbers, right? We talked about that jury verdict in LA, a couple of months ago with Liberty Mutual. I mean, I know it just got reduced on appeal to $20 million, which is, I guess, a bargain compared to $103 million or whatever it was. But we got juries willing to just rack up big money. In fact, when I did my first jury trial, I remember somebody telling me on the jury, this was like winning the lottery. Like I thought I was going to help someone win the lottery. Luckily, we defensed it. We had 12-0. But that's what they thought their job was, that if they thought that our client had done something wrong, that they were supposed to help them win the lottery, which is, I think, a lot of what we see in California with juries. I think being on a jury, I've never been picked on a jury. I would love to be on a jury. And I think they work really hard for the most part to do the right thing, but it's hard for them to understand what their role is, right? And if something bad happened to somebody, that's something that they want, they feel like they have some power to compensate for that.
Yeah, totally agree. I mean, it's a different environment. I mean, and when you think about it, and perhaps this is a whole nother subject for a different podcast, but when you think about how difficult it is to defend cases in light of who is on a jury, getting a 12-0, that's, you guys did something there with that, because, if juries are composed of unemployed people, some of whom were fired from their jobs, retired folks, and usually government people. They
Right.
constitute the majority of juries. And that's not a great pro-employer audience, to be honest.
No, it really isn't, especially when you think about the government jurors. They're used to all these procedural protections, right? Which if you're an at-will employee, they could think something was wrong when all you did was exercise at-will employment, right? So here's the bottom line. You're 100% right, Joe. It is way more risky in California because of that. It's not really because of the way the law is written so much as just the sort of mentality and philosophy, and more importantly, who actually has to serve on a jury. I mean, we let people who work a lot of times get a hardship and they don't have to be on the jury. So that's a very good point. Well, here's the deal though. The law is the same, you're saying, and obviously that Sixth Circuit standard is darn near impossible. I mean, who could ever prove that the employer intended for their employee to be harassed? I mean, I can imagine some situations, but it's a pretty high burden.
Yeah, totally agree. Very difficult standard to meet.
And, I don't know how long that's going to stick around for, but obviously the Supreme Court knew there was a conflict, right? Because the Sixth Circuit came up with something different than everybody else. Okay, so let's think about this from a federal perspective and from other states. California is pretty much in the sort of middle of the road category, right? We're not doing anything too crazy here. So let's get back to how do we investigate? How do we look at these issues? Because one of the things under the negligence standard, of course, is that the employer needs to know or should have known that there was a potential issue with this third party, right? So for example, let's say we have a UPS driver who is leaving love notes for the receptionist. If the receptionist never tells anybody about the love notes, how would the employer ever know what's going on, right? So how does an employer know that there's a potential problem with a third party? I mean, what do we want to do as employers to encourage people to speak up? Like, what are your thoughts about that, Joe?
Well, I think the first thing we have to do is make our supervisors and managers aware of our obligation. That's a critical component of it, because when we say, the company knew or should have known, a lot of them don't recognize that they are the company. And
That's right.
whatever they know, whatever they hear, whatever they see, or whatever they should know is imputed to the organization. And so there's that. And that's, of course, training and education and awareness. And an important part of it is that as well. But I think you have to be looking as a supervisor or manager or a member of HR, you have to be, on alert for the indicators because yes, sometimes they will bring it to our attention. They'll come to you and say, I don't like this UPS driver leaving me these love notes. But in
Hmm.
some cases, you might get more of a subtle comment like, "Hey, do you think we could use FedEx instead of UPS?"
Right.
And that you have to be alert. Is there something going on here? Why we've used UPS for 20 years? Why would we want to change? And so there's something going on, little things like that. And be careful too of the comments like, yeah, well, I don't like those love notes, but I can handle it or something like that. And you go, oh, okay, I'm busy. I got other things to do. You say you can handle it, you got it. And you take it from there. That's not going to usually provide a defense for you either. So it's a difficult spot for employers for sure.
One of the interesting things you said is do training. And of course, the managers and supervisors need to be trained, but I want employees to be trained too, right? I want them to know, like, if anybody you're coming into contact with, whether it's at a conference or in our office or a client you speak to on the phone, if anybody is treating you in a way that you think is inappropriate or makes you uncomfortable, I want you to speak up. And I think sometimes I've had people tell me, Jen, I know you want to talk about that in training, but could we just skip that part because we don't want to encourage people to bring a complaint? Like, no, you actually do want to encourage them to bring a complaint. You'd much rather have them tell you about it than go get the lawyer they find on Facebook, right? And go do some agreement with one of these lawyers where they're going to file a lawsuit. I'd much rather hear about it from my employee.
Completely agree. You want to have the opportunity to address the concern before they talk to the lawyer. Because once that happens, there's not a lot that you can do to turn around that potential claim.
Well, and especially one of the things that I've been thinking a lot about is the fact that once they go to a lawyer, whether it's intentional or not, the story they're telling is not the story the way you know it, right? The whole dynamic changes at that point because you have your idea as the employer about what happened. They go to see the lawyer, and even if they're acting in good faith and they think they're telling the lawyer everything that's relevant, they're only going to tell the lawyer the things that they thought were relevant. They don't know what happened behind the scenes. They don't know why decisions were being made. So there is such an incentive to solve the problem before they talk to anybody else, before they go to the lawyer, before they go to the Civil Rights Department or the EEOC. And that means you have to train your managers and supervisors. You have to train your employees. You have to say in your policies, right? Listen, this harassment prevention policy protects you not only from other employees, but also from third parties, and give some examples. And yes, be transparent. It's okay to encourage them to bring claims because that's exactly what you want. You want them to speak up. So what kinds of facts? Okay, you mentioned, Joe, sure, somebody could actually make a complaint. I think a lot of our HR professionals talk about, the difference between a formal complaint and an informal complaint. There's really not a difference, right? You complain, you complain. So I don't think your policy should talk about whether it's a quote formal complaint or informal. It should just be speak up, right? Tell somebody. And then if they tell a manager or supervisor, of course, that manager or supervisor has to know to get in touch with HR. Do we care about things like whether there's a pattern of conduct? Like, do we tell somebody to wait? Okay, well, we know there's an issue. Let's just see if this will shake out. So I'm not going to do anything now. Just let me know if it continues. What do you think about that, Joe? Like, is that a good compromise for an employer who's worried about some of these third-party relationships, like whether it's, high revenue client or something like that? Should they sort of wait for a pattern?
Well, it's a good question, Jen, and a hard question, right? Because every situation is going to be a little bit different, right? In terms of what is the nature of the behavior, how offensive is it, how is the individual reacting to the behavior, right? Everybody has different tolerance levels. And then, you're evaluating in many cases the situation, the importance of the client, all that the reality is the business is going to want to evaluate all of that. And so you have to look at all of that and then try to decide, how are we going to manage this situation? Because ideally, you would just like to say, oh, okay, you're making my employee uncomfortable. Okay, that's it. We're not going to do business with you anymore. But that may not just be realistic, right? I mean, you can't just say, oh, we're never going to work with FedEx again or whatever, because you got to get
Right.
your overnight delivery sent or whatever. You have to be creative in these situations, and you have to think out of the box, because you don't have the control over the actor who's causing the problem.
That's such a good point. And you also don't know why the employee got the perspective they got about the fact that this person was treating them in a way that was inappropriate or that made them feel uncomfortable. Like, we don't want to assume that the employee is necessarily correct. I mean, we certainly have to do an investigation, right? Which we'll talk about in a minute. One of the things I'm wondering about, because I get questions about this a lot, is what language is used, right? What if somebody uses the term harassment? Do you need to pay more attention to it than if they just say, I'm uncomfortable? Or what if they don't use the word hostile or the phrase hostile work environment or the word harassment? Does that mean you're off the hook? I mean, what role does language play in this whole thing, Joe?
Well, I tell you how I approach that, Jen, is that if they use the word harassment, you have to take it very seriously, right? And most of the time, they're wrong, at least as you and I understand the legal concept of harassment. People think of harassment as being the much more broader definition than it is under the legal standards, right? And so people use that word oftentimes in situations where it doesn't meet the legal standards. But you have to now go through all the steps because they've used that word. And on the other hand, if they don't use the word, that also doesn't mean you're off the hook, right? Because now you got to analyze the behavior and you have to assess, is it inappropriate? Is it maybe violative of your company policies? Is it maybe harassment? Because
Mhm.
sometimes they don't describe it as harassment, but you might ultimately determine that in fact it did meet the legal standards.
So we're not going to stand on ceremony like you didn't use the right word or you didn't submit the form on goldenrod paper in triplicate, right? If we have notice that there may be a problem, we have to look into it. And that is just the same way as when you have potential complaints or potential harassment or discrimination, retaliation, whatever it may be, by your own employees, right? It's the same thing. You have to figure out what's going on there. Okay, so let's just take a scenario, Joe. You have an employee, they repeatedly report inappropriate comments by a customer. HR finally decides, okay, I got to talk to management about this because it's not getting resolved. And management says very practically, look, the guy spends a lot of money with us. Just tell the employee to avoid him. Just stay away from the guy. We're not going to make them go to a conference with him or talk to him on the phone or do anything. Just stay away. Does that work? Is that a problem? Is that a good solution?
Well, those are different questions. Maybe it works because maybe the individual does stay away from the offending customer and maybe that solves the problem. Is it a
Mm-hmm.
good answer? I'd say no, it's not a good answer. It's not really the kind of response that most of us in the employment bar would suggest that you would do in order to minimize the risk. Because if just saying stay away from this person doesn't work out, you're going to be in a very exposed situation.
You really are. And I think a lot of times there's this tendency to sort of close your eyes and plug your ears and hope for the best. And I mean, that's one option, but it just doesn't usually work out that way. Okay, let's talk about investigations because we're going to be doing this webinar coming up. So we're very focused on investigations. And I think there are some interesting challenges when you are dealing with third party investigations. And there's a lot of different things, right? You have to think about what is the scope of your investigation? How are you going to gather the evidence, right? Who are your witnesses going to be? How are you going to assess credibility? Like, what if you only get to talk to this other third party, for 10 minutes? How are you going to assess that? Do you involve the other person's employer? Like, do you call FedEx and say, hey, your driver's been really behaving in an inappropriate way toward our receptionist? And I think all of these things are examples of how the investigation process can be different, right? I mean, what do employers need to look out for, Joe, when we're talking about these third party matters? What do we want them to focus on?
Well, first of all, I think you have to recognize this is hard, right? I mean, these are hard situations
Yeah.
to deal with. You may not have access to the parties that you need the information from in order to reach the conclusions for the investigation. You don't have any control over them. You don't really have the ability to take any action or punish them or discipline them or really do anything. They have no obligation to participate in your investigation. And in some circumstances, they may even hold the cards or be perceived they hold the cards because of the business they provide to your business. So these are very difficult situations. And in my mind, they're much harder to resolve successfully than our internal inappropriate behavior complaints and internal investigations.
That has certainly been my experience. Do you feel like, Joe, that let's say we run Acme Company and one of our employees says, okay, there's this vendor who's causing us grief and I want you to do something. Do you feel like you should reach out to the vendor's employer or somebody who's maybe in that organization before you try to start investigating? What are your thoughts about that?
Well, again, I think it's a little fact specific, right? Like
Yeah.
what exactly is the behavior that is involved. But one of the things that's a brighter spot, I guess, in these situations is that I do believe the law recognizes that employers, when dealing with third parties, have limited options available to them, right? You don't control that employee. You can't fire that employee. So there's only so much that you can do. But you better show that you've done all you could do, right? And that oftentimes includes reaching out to the individual's employer. You may not be able to talk to the person that's in charge. You may not be able to talk to anybody at some of these big, large organizations, but you better show that you try.
That is such good advice for everything in the workplace, right? For every workplace law we talk about. You know, you better have tried to engage in the interactive process. You better have tried to prevent disputes in the workplace. Like you have to make your best effort, right? You have to actually treat these employees who are making complaints like they're your favorite employees, right? They may or may not be, but what would you do for your most favorite employee? That's what you better do for everybody, right? When we talk about mistakes in this area, Joe, what have you seen employers do? Like with respect to these third party claims, what kinds of mistakes have you seen employers make? What are those common sort of rakes that people step on that we can maybe help them avoid?
Well, the first one we've mentioned several times already. That's throw up your hands and say, I
Yeah.
can't do anything about this, right? It's not my employee. I don't have any. That's probably the biggest mistake I see, especially with small and mid-sized businesses, right? They just sort of acknowledge this is not their employee, and so therefore they conclude that there's limited options for them in terms of their ability to manage the situation. But as we've talked about, there are things that they can do. But other mistakes, you wait too long.
Yeah.
You sort of this gets backburnered. It's another company's employee. It's not something that we're necessarily rushing to try to complete. We're not able to investigate it as thoroughly, so we don't collect as much information because it would be hard and would take a lot of work, and we got to try to track down these people that were at this conference with these folks and try to talk to them and who was at the bar that night and all this. And that's a lot of work and a lot of hassle. And then, we don't document well what we did do. And like I mentioned just a second ago, with reaching out to the employer and commenting about some inappropriate behavior by one of their employees, making sure you can show that you took that effort would go a long way to defending one of these cases. But a lot of times employers don't write that down. They just reach out and they call and they get frustrated and they quit. And again, the worst thing you can do is throw your hands up in these situations.
Well, and one of the things I see, Joe, is They try to call the other employer and they're unsuccessful. And then, like you said, they didn't document it. So 2 years later, they say, well, I tried to reach out. Oh, really? On what day? I don't know. Well, who did you talk to? Well, I left a message. Well, who'd you leave the message with? I don't know. I mean, essentially, if it's not written down, it didn't happen, right? I mean, that's really like rule number one about workplace documentation is you got to write it down somewhere. And I think some people think it has to be in some fancy journal or you've got to have some, high-tech program where you have an HRIS system and you're tracking everything. The truth is you just have to be able to find it. You just have to be able to say, hold on, let me look back at my notebook and I'll see when I made the phone call and I'll be able to tell you what happened. I mean, that type of documentation is critical. Even if you're unsuccessful, even if you don't reach that person, at least, as you said, Joe, you can try it. Okay, here's another interesting issue with these third parties, folks. Let's say you can do an investigation, right? Well, let's just say, of course, you're going to do an investigation. How thorough it's going to be and how much you're going to be able to get from the other side is an open question. But you're going to initiate the investigation. Now you determine what you think is more likely than not to have occurred, right? Which, remember, that's our standard in investigations. It's not beyond a reasonable doubt, right? It's 50% plus a feather. So you decide what you think likely happened, more likely than not. What can you do about it? Like you said earlier, if it's a big company, maybe you can't sever the relationship. What are some creative things that employers can do to deal with these third-party claims?
Jen, it starts with the basic concept of conflict resolution, right? And that is to actually express your concerns about the behavior to the person who's engaging in them. And there is nothing that prohibits you from doing that with a third party. And I think for some reason, employers and HR people are reluctant to do that, right? Where they would have no problem making that comment to their own employees. They're not willing to do it with a third party. And I think that's a mistake. And I think that is one way, oftentimes, to cut off the inappropriate behavior, right away. There are other creative things that you can do to try to limit the risk in these situations. I mean, you can change the way your packages are delivered. You can require them to leave them outside. You can reassign somebody else to work with that particularly problematic individual. It takes a little bit of work, and you have to be careful to make sure that the individual who's adversely been impacted by the behavior isn't also adversely impacted with respect to their job or their compensation or their bonuses. So you have to be alert to all of that. But there are creative approaches. And again, this just comes back to me anyways, that you just can't throw up your hand and say, I can't do anything about it. The expectation is lower with third parties in terms of what the court's expectations are, but they're not don't do anything, right? It's you have to try and take reasonable efforts. And if you do that, I think you'll put yourself in a defensible position.
I think so too, Joe. And I think that there's this phrase I always say to Ella, we can do hard things. And we can. I mean, she had this horse show this weekend that was so hard and so competitive. And she did great. I mean, did she get close to winning? No, that was not the point. She really learned how to do what she needed to do. And at the end, she said, Mom, that was so hard. I know, I get it. And we can do hard things, right? And HR people, we get so overwhelmed. We have so much going on in the world. And sometimes we think we can't take that one extra thing. But this is not where you want to shortcut it, right? Just as you said, Joe, you've got to take the time to figure out what's going on and show your employees that you care about them. Because let's not forget, if your employee thinks that you didn't take action with respect to this third party, they think you don't care about them. They think you're just blowing it off. You're too busy. It doesn't matter to you. You could lose a really good employee. And we all know how hard it is to recruit them and train them and coach them and mentor them and try to make them successful. Like, it's tough. And you don't want to invest all this time in someone and then you do something to interfere with the relationship where they feel like, look, I don't believe in the integrity of this process anymore. I don't want to work in this organization. So I think there are also a lot of sort of externalities that come up that are not direct legal liability, but they're consequences that we need to take into account when we don't do these things correctly. So before we wrap this up, Joe, just to summarize, all right, of course, third-party misconduct can create liability for employers. We've talked about that. You made a great point that it's not always going to be this written complaint that we receive as an employer. It might be something like, oh, Paul's coming to the office. Well, I think I'm going to call in sick, ha ha. And then we got to figure that out. Like, well, what's going on? You got to be willing to drill down. Certainly, as you said, Joe, we don't control third parties, but that doesn't mean we shouldn't respond at all. And we certainly control our own response in our own organization. We certainly have that responsibility to take whatever action we possibly can, even if it is likely to be less effective than it would have been if the conduct occurred inside our workplace with someone who is also working with us. Joe, do you have any last minute sort of words of wisdom for our listeners about this issue?
Well, I think you covered it really well, Jen. I think the issue is be aware, understand your obligations, train your managers, and don't throw up your hands.
That is exactly right. Everybody, Joe, thank you so much for joining me today. I love it when you come on. It's so much fun. Thank you.
It's a pleasure. I look forward to working with you on the investigations seminar.
I do too. And that is a good reminder, you guys. One final reminder, join Joe and me on June 2nd for Getting Investigations Right, a California Employer's Playbook. We're going to take a deeper look at conducting defensible investigations in California, and we're going to share practical approaches that you'll be able to use immediately. Remember, it's complimentary, and there will be live Q&A. You can register at employerslawyer.com/investigations. Thanks for joining us today, everyone. We'll see you next time. Shaw Law Group, we solve workplace problems. Real-world guidance for real workplace decisions. The Workplace Wake Up podcast is produced for general educational and informational purposes only. The views expressed are those of the speakers and do not constitute legal advice or create an attorney-client relationship. The law is complex and constantly changing. Therefore, you should contact an employment lawyer in your jurisdiction for advice regarding your specific situation.